On record, we'll go to the 8:15 compliance calendar. Ryan Kites. Mr. Kites, come on up, have a seat at the council table and. Docket note I have, Mr. Kites said we have an SOC that's kind of past due. But we need a victim impact panel, alcohol and drug information school. Where are we?
I don't know. I took those things during COVID time. They're all through Zoom. I assume the court was supposed to have them sent to them. The only thing I produced to the court that I remember from that time was a receipt of payment for, if not both, at least one of those classes. Not sure if that was taken down as a copy. Ultimately, I had no idea this was a thing, thought it was over with, and here we are today.
No, the last thing we have on record is the March 10th, 2020 eval from First Things and recommended the usual no significant problem, low probability recommendation that you do get it, but we don't have any proof of that.
I'm unaware of where I went. Any documentation, computers that I've had have all been given away. I have a short prognosis left. So I just kind of started giving everything away, not thinking I'd ever need it before I meet my demise.
There is a docket entry here during the height of COVID that you had ADAS and victim impact panel. It was scheduled, but the Zoom went down and the classes couldn't be done, and we'll be checking for the next available. That was September 2020, and we're kind of still coming out of COVID. Well, it's an SOC. Hate to revoke an SOC on a DUI for something that's fairly minimal. What do you want to do?
I have no idea. I mean, I don't know what my options are. Like I said, I didn't ever intend to have to deal with anything like this.
Minimal record following the data violation, which goes back to.
I'm comfortable closing the case with no action.
The impressive thing, Mr. Kite, is no subsequent offenses alcohol related. You've had a few blips with the license. It sounds like that is just something to be dealt with over time. How is life going otherwise?
It's ending soon.
Yeah. The fact that you haven't reoffended would indicate to myself at least that those classes are perhaps informative, but maybe not necessary in your case. And the city is agreeing with that. We're simply going to close the case, give you the benefit of the bargain, give you the reduction called for in the SOC, and that will be the end of that. All I can do is wish you the best of luck and indicate that, yeah, a second DUI would be one of the worst things you can do.
Yeah, it's just not a physical possibility anymore.
Well, I'm glad to hear that. I won't ask you for the reasons, but I am glad to hear that.
Thank you.
Life is going otherwise pretty good.
Yeah, comfortable-ish.
That's, well, you're here, you're upright, taking nourishment, and that's all any of us has a right to be thankful for and expect, or hope for, I should say. You take care of yourself, and again, that'll be the last time you have to come to this court on this thing. So, case closed.
Thank you.
Okay, good luck to you. Take care of yourself. Derek Murphy. Not Derek Murphy. And you are last name? I don't remember seeing you on that. Is Mr. Magdalene? On the document. Did you think you had court today? What time? Didn't make it to the calendar, but you are, that's yeah, I'm scheduled. I just didn't know anything about it. See if we can figure out what the problem is. Your lucky day. You're here, you're on time. You are scheduled for today, but for some reason it didn't print out on the docket, but come on up and have a seat. While we wait, how's life going otherwise?
Not so bad. Renovating my apartment.
Any idea why we yarded you in here? Usually it's a compliance issue of some kind.
They're gonna see if I'm going to rehab.
What now?
Just making sure I'm going to the rehab.
Okay. Anything going up to date on that?
I thought they would have sent you guys paperwork, but yes, I've been going to my groups. I have a counselor's appointment on the 25th.
It's very often, post disposition of a credit case, there's hoops to jump through and sometimes they present difficulty in doing that. There's money involved and expenses involved and better late than never. The important thing to me is, has there been any reoffense for the same thing?
No, I
That
don't
would be it. Should have notified, you now of record, in full compliance, and, so the case has been, stricken, the hearing today. We wasted your time bringing you in here, but it's good to see you healthy and doing well.
Thank you, sir.
You know what else you have to do? Is there any more follow through, indicated? Not having the file in front of me, I just don't know and don't remember.
I've got about 21 more groups, one section, 21 more sections of one group. 13 more sections, another group. And I'm to attend one AA or one NA, or no, 2 AA or NA meetings a week to remain in compliance.
Are they doing you any good? Are they helping you live life, learning anything?
A few concepts I wasn't familiar with before, but nothing I didn't already teach myself.
Like I said, sometimes there's hoops that mandated you jump through. And that's sometimes they're found to have helped in many cases, but in other cases, inevitably they're unnecessary but required by law. But Mr. Hibb, I want to thank you for appearing. Thank you for your patience, and as long as you're in compliance and staying up with your groups, that's we won't be pulling you back in. And if stay in touch with us in case there's any question you have. Good luck to you.
Thank you, sir. You too.
Okay. We do. Oh, boy. Yeah, that's just been going on. Been bouncing in and out. That was a huge form. We do have the 1/8/15 that didn't show. Derek Murphy, is we're at the end of jurisdiction, no treatment compliance. Apparently, he's has a bail bond posted. He was booked on a warrant, released with his promise to appear.
Forfeit. I don't know, what do you tend to, what do you do with these? Yeah.
What now? Okay, that's it, yep. We'll forfeit the bond. Aladdin will not be happy with that. And of course, by statute, if they return the individual to custody within the year, the bond can be unforfeited. But
Okay,
let's see how that goes.
yeah, all right, so move the forfeit.
Mr. Murphy.
Morning, Judge.
Yeah, Mr. Aberco, are you able to hear me?
I am. Can you hear me, sir?
I certainly can.
Thank you, Your Honor. So this is, let me a second, I'll put on my glasses here. This is Michael Ward, and we intend on entering a plea. I know Your Honor last time didn't take a plea, and one of the issues, just, for the record, that was going on was whether or not the county was going to pick up the charge. And I had a little communication with the city prosecutor last night, and their point of view as well. we don't hear anything from the county by 4 PM, let's just go ahead and proceed with the plea. So he hadn't heard anything. So based on that, I prepared an electronic statement of defendant on plea of guilty for Mr. Ward. I've reviewed that with him. It's in O courts, and he'd like to proceed today and proceed with sentencing here. He's been in here a while and wants to, I think, just kind of get this case over with if you can.
Did he have any comment on what was just said?
Oh, no, Mr. Haverco accurately described my interactions with the county and himself.
That's fine. With that in mind, I have pulled up in Oak Courts a statement of defendant on plea of guilty. Good morning, sir. Are you Michael Andrew Lloyd Ward, Senior?
Yes, sir.
Good morning to you. I'm looking at a statement of defendant on plea of guilty to one count of violating a protection order. Plea form tells me you're 34 years of age. How far did you get in school?
I got my GED in prison, sir.
Any issues reading, understanding the English language?
No, sir, not reading.
Have you gone over the plea form with Mr. Haverco? And if you had any questions about what it meant to enter a plea in this matter, were your questions answered?
Yes.
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal. That'd simply be a sentencing that could be up to the maximum regardless of what's recommended. Do you understand that?
Yes.
With that in mind, as to one count of violating the terms and conditions of an order of protection alleged to have occurred within the city of Yelm on May 10th, 2023, how do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yeah.
Anybody make any threats or promises to you to make you plead guilty?
No.
I'll find the plea to be freely, knowingly, and voluntarily made. Your statement in paragraph 11 reads, on May 10th, 2023, in the city of Yelm, while an inmate at the Municipal jail, I contacted via phone the protected person, Marion Whitman.
Protected person contacted me.
I'll find that satisfies
He
the
had contact.
of the offense. I'll find the plea to be freely, knowingly, and voluntarily made. Anybody make any threats to you to make you plead guilty?
If I may, Your Honor, I would like to state that
You'll have
Doesn't matter.
anything you have to say. Yeah. But anybody make any threats to you to make you plead guilty? Or promises other than the recommendation?
I'm not sure exactly. I apologize for speaking out of turn, Your Honor. And from my understanding, the recommendation is be getting out today. And I'd like to make the statement that the person contacted me. You know, and that doesn't matter. And I did speak to them, absolutely. I have a service animal, but no threats were made to me, sir. I apologize.
But that's been part of the procedure. I have to make sure that nobody made any threats to you or promises to you to enter a plea, accept what's contained in the statement.
I've actually not read the statement, sir.
It's a lot of it applies to you. You want to take a moment to?
Yeah, do you want to?
Yeah, yes, please.
So do you want?
Your Honor, I actually feel that I'm being intimidated and forced into making this plea by counsel. I'd like to make a formal complaint to the Bar Association. And I feel that he's acting highly unethical and against his standard duties as public counsel. And no one cares.
Mr. Haverko leave the room?
No, he's right here.
Yeah, I'm right here, Judge. I thought he wanted to enter a plea and wanted to discuss that. Apparently I don't know. I can't figure out what he wants to do. So he's angry at me. I don't know why, but I've just prepared a plea. We've gone over this several times. He understands the rights he gives up. I was trying to explain to him that I think he's frustrated with this point of who initiated contact. And it's really not the issue. If someone calls you, if the protected person calls you, it's your job to not respond. So whether or not you reach out and make contact, or someone contacts you and you respond, it's sort of immaterial, really. And so it's sort of a distinction without a difference, but I don't know, this discussion is just leading to, I don't really understand what Mr. Ward really wants to accomplish or do.
What I'd like to accomplish is for this to be over and for me to get on with my life, sir. My family, I have irrelevant. What I would like is for justice to be done. The fact in this to be over. A lawyer that does their job and not intimidate and coerce me and manipulate the situation for their betterment and to hurry up and get me out of here. When this case was first started, I had asked for a counter order to be involved because I've already been through this before and I've done 3 years in prison over the other person contacting me and bailing me out. I asked for a counter order because I knew she was going to contact me. She has my service animal. I have extreme mental health conditions, including PTSD and other things, and she has my service animal. The conversation with her was, with whoever had called me, was, excuse me, how is my service animal? And that was the end of it.
We're not going to argue the case at this point. We can't argue the case at this point.
It's ethically wrong, sir.
Hold on, please.
Completely ethically wrong.
The way the system works. Now, yeah, of course, you want it to be over. When I get the flu, I don't want it to be that. I want it to be.
This is different than the flu, sir. This is extremely different than the flu.
Maybe that was an ill-chosen metaphor.
This is my life on the line, sir. This is years of my life. She's pregnant with a child of mine. How do I fix that? You know what I'm saying? I've been assaulted. I've been whatever. So I'm supposed to simply sit here and take the court's recommendations when it's going against everything ethically that I should stand for, what they should stand for. And because this man doesn't want to do his job, I don't believe in that no matter what, Your Honor.
You have the right. You have the right to go to trial on this if you wish. It's your case, it's your choice. You don't have to plead guilty. And that's why I asked you, is the plea being freely, knowingly, and voluntarily made?
In this instance, on this case, it would be freely and knowingly. Yes, I did break the no contact order, but in the case before this, as far as the assault and everything goes, that was not freely inputted. That was based on coercion by counsel here. Threats by counsel here. That if I do not do what he says, it's going to be worse. And I asked for new counsel, sir.
Mr. Coleman or Mr. Ward, that's based on the statements you made. I can't accept a plea on the new violation today. What I'm hearing from you is you're being muscled into resolution. The thing you just don't want to, you just want to be over and get on with it.
And I will freely and openly put in a yes plea today on this charge, but I am saying, and I'm making this fact, and I will be making a formal complaint against counsel that this is wrong. This is absolutely wrong. This man right here has no business in this field at this point. None.
Mr. Ward, that's a matter between you and Mr. Haverco. If you feel like you need to make a complaint to the Bar Association, you're entitled to do just that. And you can do just that. But however, what we're addressing is this protection order violation of May 10th. I reviewed a statement of defendant on plea of guilty, and I really can't accept the plea based on what you've been saying about you've been sort of muscled into the whole procedure. I won't accept the plea today. Your rights are.
My rights are being completely violated, sir. Under 23 for USC 182340A, I feel that this is psychological torture by public officials at this point. And I apologize for that. And I apologize for anything like my opposition to the courts, but what's right is right, and none of this has been right. And I even apologize to the victim. She didn't deserve it. I have psychological problems, right? But the way that these proceedings have gone is not right at all. My treatment here has not been right at all. And I apologize for my treatment to her. I give that 100%. She didn't deserve what had happened in the initial what happened, right?
Mr. Ward, I'm not going to engage in a dialogue about anything.
You will be engaging in a civil suit is what's going to happen.
Okay, that's you're free to pursue any option you think you're justified pursuing. What we have now is I'm not going to accept the plea to the protection order violation. I don't feel I can legally, based upon what you have said about that. We'll turn to the other matter, which is the compliance with the sentence imposed in docket number 4982, which was the initial assault.
Your Honor, I think I'm gonna ask for another continuance on this, considering what's transpired today.
Hey, Mr. Ward, we're simply going to continue both matters pending. Ma'am, are you involved in this case? Okay, I just wanted to make sure of that. I apologize. We're just going to set this matter over to the next court date. Allow the parties to discuss things further. Mr. Ward, that's with regard to the attorney you have. I'm familiar with Mr. Haverco. He's a very capable, very competent attorney and very experienced. And let me talk, please.
I don't feel the same about that, sir.
And you can disagree with me, and I can see that you definitely do. You're entitled to competent representation, and I'm finding that you have that. You're not entitled to the attorney of your choice. You can retain an attorney if you wish. That's your choice as well. But that is going to conclude today's hearings. I'm continuing everything to the next available date.
Thank you, Judge.
Thank you, sir.
Thank you. Yeah, I see that. It looks like it's one of those disposals, it's actually kind of a predisposal case. Yeah.
Hello, sir. Hey, Judge, this is Mr. Coleman.
Good morning, Mr. Coleman.
Hello, sir.
Eric Lavelle Coleman.
Yes, sir.
Mr. Abaco, we're here on the SOC that was entered back on September 6th of 2020. In the meantime, there was a new DUI charge in a couple of months later that's actually still pending in the county. Conditions of the SOC involved an assessment, ADIS, and victim impact panel. Mr. Coleman has apparently done absolutely nothing of record here except to get a new DUI.
Well, I came to court for a year straight. Remember, I was there for every month for 1 full year. I came to court for a whole year straight and kept getting continuances. And then I got a new lawyer and he gave me the, what was it? What was that? There was one of the things that he did. It was some kind of agreement that we had made, but I had come to court every day for a year straight. And then I lost my vehicle and that just made it so difficult.
Mr. Abaco, anything to add there?
Well, I was asking him, like Your Honor had mentioned that the SOC stipulated order of continuance had started in September 6th of 2020. He would agree that nothing has been, completed. The notes indicate there's no assessment, no alcohol drug information school, no victim impact panel.
That was
I think his position is that he was living somewhere far, 20 miles out of town somewhere
Bald Hills Road.
without either transportation or any means to really commence with his obligations. And now things are, according to him, different. He says he's living in town. I did ask him if he has employment. He said no. And I did mention that, it does take some money, not necessarily a lot, but it takes some money to pay for evaluations and classes and things
I'll
like
figure that
that.
out.
So,
I can make that
he
happen.
would just insist to the court, I guess, that if the court would allow him, he would, he would now tackle his obligations now.
Fully.
Because he's in a better position to do so. I think that's his position, Judge.
I really want to get this done. I want to get this behind me, sir. I've been dealing with it quite a while now, and I just want to move on with this and just get it done. Please.
Actually, it's a stipulated order of continuance. It's a contract between you and the city. You're in clear violation of it. The case is over 6 years old. City have a position or a motion that sounds like Mr. Coleman is asking for more time.
The city's comfortable providing more time.
Or I mean, what can I do? What can I do? Is there, what can I do? For one, I need to get out of here for one. I don't know what I need to do that. Whatever is required of me, I will do.
Well, get a drug and alcohol assessment and comply with any recommended treatment is the baseline here. However, you've bounced in and out of warrant status over the last 6 years. We set you for another court date. You never show up, and
I've been in here for 2 weeks now.
Yeah, but and the reason for is you never come to court.
But I will come to court. You've seen me for a year. I will come, sir. I promise. Just give me one chance, please.
I've already given you 4 or 5 chances, but hey, we'll try it again. Mr. Ward will reset the matter for a compliance hearing, first court date, maybe in August, Mr. Abercrombie?
Yeah, I assume you'll set him on the out of custody calendar, see if he shows.
I will show. I promise, sir. I promise I promise you'll see me.
17th, maybe. August 17th. You're going to get a copy of the order resetting the matter to August 17th, Mr. Coleman. But yeah, that's after this amount of time, probably a good idea to kind of address the matter. Okay?
Yes, sir. Yes, sir. You're very right, sir. And I apologize to the court and for wasting time and making this drag on so long.
You're wasting your own time being in jail. Now, I'll release you on the, I did keep you in on very minimal bail, which you apparently haven't been able to post.
Yeah, I'm just, yeah.
We'll release you on your promise to, A, stay out of trouble, and B.
Thank you, sir. I truly appreciate you, Judge Meyer. Thank you, sir.
Mr. Coleman, you can thank me by showing up, getting
Yes,
this,
sir.
and most important, stay out of trouble.
Yes, sir.
Good luck to you.
Thank you, sir.
Thank you, Judge.
Back on record for the 9 o'clock calendar, Ms. Callahan, good morning.
Good morning, Your Honor. For the record, Linda Callahan appearing on behalf of the CTRs. And my understanding is the city has a motion.
Yes, Your Honor, city's moving to amend the charge to negligent driving in the first degree.
So noted, accepted. Good morning, ma'am. Is your full name Carly Heather Gutierrez?
Yes.
Gutierrez, if I mispronounce your name, I apologize. If there's a way to mispronounce a name, I'm gonna find it. Plea form tells me you're 42 years of age. Any issues at all reading, understanding the plea form? And if you've gone over the plea form with your attorney?
Yes.
And if you had any questions about what it meant to enter a plea of guilty to an amended charge of negligent driving first degree, were your questions answered?
I don't have any questions. Yes, there.
Neg driving, neg one, it's called, is a misdemeanor. The maximum penalty on conviction to be 90 days incarceration and or $1,000 fine. I don't know what the recommendation, I haven't scrolled down to that yet is, but I'd be free to impose up to the maximum if I thought that was necessary. And if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, no witnesses, simply a sentencing. With that in mind, as to one count of negligent driving first degree alleged to have occurred within the city of Yelm on February 26, 2023. How do you plead, guilty or not guilty? You make that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make the plea guilty? I will find the plea to be freely, knowingly, and voluntarily made. There is no statement in paragraph 11. Based upon my review of the statement, I do find that there's a factual basis for the entry of the plea, and I'll accept that unless there's any objection from the
Thank you, Your Honor. I don't have court access, so it makes it hard.
being a computer dinosaur myself, I struggle with the cyberspace, but hey,
So do I.
times change, times change. But I will find the plea to be freely, knowingly, voluntarily made. And as I said, I can't accept the plea unless there's a factual basis for it. And I find that there is based on the police reports that I've reviewed.
Thank you.
The recommendation is 90 days, all suspended. On conditions, any recommendation is to fine. It looks like fine is suspended. Ms. Raphael, no recommendation is to fine.
No recommendation.
And the other conditions are, of course, law-abiding behavior, stay out of trouble, don't in any way, shape, or form repeat what is a mistake people make. Don't refuse any BAC that any officer asks you to take, and of course, no criminal law violations. That's the recommendation, Ms. Callahan. I'll hear from you. If
Thank
you have
you.
anything to add.
We're in agreement with this city's recommendation. She did receive a license suspension, unfortunately. So she'll be getting her ignition interlock license and so forth. So she has learned a lesson from this, Your Honor, that I'm confident you won't see her back again.
Scooters, you have what they call a right of elocution. You can tell me anything you wish to let me know. You don't have to say anything. You can rely on the. I think all I'm going to say is this: you owe your attorney quite a debt of gratitude. I've said many times, and I fully agree that a DUI conviction is far worse in terms of impact on your life than a lot of felony convictions. And again, the reason for severity of the consequences are, you read the paper, the number of people we kill because of and that's done by people that ordinarily wouldn't step on a bug. It's just one of those tragic things that happens. Follow the recommendation. No fine is recommended. I won't impose any fine, 90 days jail, but all suspended on the condition you comply with the terms of the sentence. Most importantly, learn from mistakes. as a human, I believe that I should learn from my mistakes and go on to make new ones rather than repeat old ones. Sometimes that's better said than done, but I'll give you the same advice. Any questions at all? All I can do is wish you the best of luck, and yes, there's all the requirements that the Department of Licensing imposes on you that are independent of anything I do. But those will all get behind you, and eventually, down the road, this will all be behind you. Good luck to you.
Thank you.
Scallahan, good to see you. You take care of yourself. I'm signing the off on the plea form now, then I'll sign the judgment and sentence, and you can get a copy of that at the window
Very good.
before you leave.
Thank you.
There's good luck to you.
Thanks.
Take care of yourself.
It's good to see you again, Your Honor.
Thank you. It's not letting me edit. There we go. Having trouble here. No, I think let's, yeah, let's, it froze on, but then it unfroze. Sorry.
This gentleman is continuing now.
Okay, is she on?
Mr. Girl, drafted a motion to continue, that's in the course and it's been signed.
You and that, no. They're not going to appear, waive presence.
Yeah.
Reset to July 20th, according to the,
Yeah, I talked with Dan.
Morning, Mr. Woody. I'm assuming that this is, Mr. Victory, your client. It is. Good morning. I'll turn to you for the status of the matter and then.
Yes, Your Honor, city has a motion, city's moving to dismiss, without prejudice.
I hear no objection.
No objection, Your Honor. There's also a matter, Your Honor, it's in motion, it's not on the calendar, it's currently not set for the hearing. It's, 380-18891. Motion on that one as well. To the lower bench with that cousin. Madam Clerk, so, did you get that cousin? Okay.
Citing the order of dismissal in case ending 1240. Mr. Victory, I can't imagine a better resolution of the matter than that. So good luck to you. Thank you. Yeah.
Well, mail them.
Okay, you take care, have a good day and good luck.
Thank you, Your Honor. Thank you very much.
Now on record, I'll defer to the parties for the order in which the cases are called. I see we have an interpreter matter. Perhaps we should handle that one first. Mr. Mold, good morning. Do you solemnly swear or affirm that you will accurately translate from Spanish to English, English to Spanish, all that is said in this matter? Yes, sir. Okay, thank you. Good morning, sir.
Good morning, Your Honor. So this is Mr. Mardonio Ramos Nuno. He's number 9 on the calendar, 10 o'clock calendar, comes before the court for a pretrial hearing on a DUI charge. And we have submitted into both courts a petition for deferred prosecution and a proposed order. Yes, for the prosecution, handing forth a copy of the evaluation that he had with Margaret Coopride, Freedom Recovery Center. The initial evaluation, she didn't realize that he wanted to do deferred, so it didn't recommend that. And then he contacted her and said he wanted to do a deferred. So she modified the evaluation to recommend deferred. So, yeah. And so I reviewed with him the petition for deferred prosecution with the defendant, with the assistance of the court certified interpreter and all of the obligations involved. And I believe he understands that to be on probation for 2 years of active probation, followed by 3 years of unsupervised probation, for a total probationary period of 5 years, after which time, if he complies with all of the conditions, the matter can be dismissed.
The only question I have at this point would be the language issue. Is there is there a need for an interpreter here, or do they offer the treatment with a
Oh, does this Freedom Recovery offer interpreter services? I don't know, but he does speak situationally. I have spoken with him without an interpreter, so he does have some English language ability. It might not be sufficient for legal proceedings today, but I gather that he is able to communicate as necessary. And then he also has with him his significant other, which I'm sure she, assists him with that. So I don't anticipate there being a problem of him participating based on any language difficulties.
That's Mr. Ramos Nuno, good morning. Petition for deferred prosecution basically means that hey, I have a problem I need to take care of, and I want to take care of it, and I will do so. It's I thought at times it's sometimes easier just to plead guilty to a DUI and accept the sentence. And the harder path would be the deferred prosecution route, the treatment route. I'm going to accept I reviewed the petition here, and I reviewed the evaluation, and I'm going to approve of the order, but it's very important that you follow through with the treatment. If you do, eventually the matter is dismissed. And if you don't come back, there's jail time of up to 30 days, up to 364 days. I want to make sure that this never happens again, and it looks like you're committed to doing that. Mr. Atfield, I see on the petition there's a place for your signature, and at the bottom there's a line for Mr. Mold to sign off on. So
am not seeing a signature line on the petition for me. Maybe,
Prosecuting attorney,
oh, I think it's
this is in the petition.
those.
The findings of fact.
There we go,
Conclusion.
yeah, that, I see my signature line.
There is and in the cost, it's, there's 500 and then 1,000 below that.
Well, there's two I was studying the petition and I put in $500 of probation costs because it looks like there's pre-built into the forms. Another $250 for something and then another $250. So it should come out to be a total of 1,000. Yeah, yeah. Yeah,
There will be the
Well-
total cost of 1,000.
the total cost, yeah, because there was a mandatory $250 interlock or yeah. So I don't think the parties wanted to overpile on the costs. So it already requires 500 for two different funds. And so if we had imposed what the original fine would be on the DUI,
990.50.
and this guy, he's worked pretty hard and I think it's better if he has a little bit of money left to pay towards treatment.
And we are locked in on those costs though.
Well, they were in the forms. Now, I was just looking at the form in Oak Courts and I don't know. That's the only reason I put in the 500 because
It was in the form.
yeah, I haven't researched if those are required. I mean, if your honor is inclined to waive those, we'd ask the court to waive them.
I am.
Oh.
It's,
And then the deferred prosecution part, so I don't legal 500, it would just be that we imposing a probation.
Oh, we don't.
It would be that-
Oh, well, I'm fine with that. I assume the city wanted a probation fee. They often times do, but if the city's willing to waive the probation fee, yeah, that'd be great.
I'm willing to
Oh, thank you, Jack.
Waive it.
Yeah. That should reduce to 500. Okay.
Yeah.
signatures from Garrett.
And then who do you sign them up?
It's right at the bottom. Yeah, it's right at the bottom.
I could have the interpreter sign too.
I'm certified,
Yeah,
I'm a certified interpreter. It's
so why don't you go ahead and sign them?
Oh, there we go.
The interpreter signed it.
Got it.
And the order.
Got it. Yeah, the forms for the deferred prosecution, they've morphed so many times over the years I've been doing this. I'm trying to enter a defendant must contact probation no later than, so we don't have. probation.
No, so you can just,
What is that?
but we have to enter something, otherwise it won't. save. So we can just. But. Let her do it. They'll leave a message, but. we'll just-
Okay. In the petition, there's this mandatory reporting date, but pretty much ignore that. It won't let us proceed without. How about the total of $500? Can you pay that at $50 a month? I'll take your nod as a yes. There always, I'm gonna wish you the best of luck with this. If you've chosen the more difficult way to proceed in this matter, I respect you for that. I want to wish you the best of luck. And make sure you keep contact information on file with us, just in case we need to bring you back in for some reason. Sometimes we don't get the necessary reports from the treating agency. But everything will work out as long as you're in compliance with the program. Do you have any questions? You'll be able to get a copy of the order at the window outside the courtroom. Mr. Mould can help you with that. And if you have any questions about that, get a hold of Mr. Hammer. Good luck to you, sir. Have a good day. Thank you.
Mr. Malone? So this is, Judge, this is Mr. Maloney, comes on before the court, matters number 6 and 7 on the 10 o'clock calendar. Goes before the court on pretrial hearings on all charges. Parties have reached an agreement. He's going to be entering a straight plea to the disorderly conduct. City will move to dismiss the assault. This had to do with essentially a alcohol and a bar situation.
I remember the case.
Yeah,
So,
and then the city is just gonna move to amend the suspended driving secondary charge to an infraction as his current suspended status has been changed by DOL to DWL's third. So that's
recommended fine on that.
Would be 150 on the,
Morning, sir. For the record, is your name Shane Ryan Loney? Good morning to you. I'm looking at a statement of defendant on plea of guilty to one count of disorderly conduct, which involves a dismissal of the fourth degree assault charge. The offense of disorderly conduct is a simple misdemeanor. The maximum penalty on conviction would be 90 days in jail and or $1,000 fine. Now, I would be free to impose that up to the maximum if I saw fit, regardless of what's recommended. Plea form tells me you're 31 years of age. Any problem at all reading, understanding the plea process? What I mean is, if you had any questions about what you were doing here, were your questions answered by your attorney?
Yeah.
Anything you'd like to ask me? You accept the plea, you give up the rights contained in paragraph 5. There's no trial, there's no appeal, simply a sentencing. With that in mind, as to one count of disorderly conduct alleged to have occurred within the city of Yelm on April 23rd, 2023, how do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will?
Yeah.
Anybody make any threats or promises to you to make you plead guilty?
No.
I will find the plea to be freely, knowingly, and voluntarily made. Recommended sentence is 90 days, but all suspended, and a probation fee of $250. Mr. Redfield, anything to add to the recommendation? Mr. Everco, anything?
nothing to add, Judge.
Mr. Maloney, you can tell me anything you wish. You don't have to say anything. You can rely on your attorney's words and actions. But if you have anything to tell me, now's the time.
So for the fine, we do payment on that?
Oh, yes.
My number one priority.
We'll get to that. I haven't posed anything yet. That was, but if there is cost or fine, there'll be payments.
The priority right now is that get my license reinstated.
I want that to be a priority. I
Definitely.
if the fines here or the probation assessments here, well, let's go 25 a month. If we get to that, but if any fine interferes with you getting your license back, I want you to let us know that. We can always put off the payment of any costs. I will impose the recommended sentence, 90 days, all suspended on the condition you have law-abiding behavior, $250 probation fee. Set that at 25 a month with the proviso. Let us know if there's a problem. This I remember the case. It happens in a. This happened in a bar. That's over the about a half century that I practiced law and done this part of that time, but. Nothing good happens when tempers raise in a bar. The best thing to do when that happens is to get out. It's because when everybody's drinking and everybody's amped up, sometimes things get a little carried. People sometimes get put in the hospital. Some people die. Nothing good happens. So hopefully this has been a learning experience. Disorderly conduct is much less of an offense than assault in the fourth degree, which is a gross misdemeanor. Hopefully, yeah, the advice I can give you, if you're in a situation like that, the best thing to do is to, if you're paying attention, you can see things, they sort of develop. If you catch it early enough in the process of that, you can slide out to a different venue. I'm going to wish you the best of luck. I'll sign the order. I want you to get a copy of today's judgment and sentence at the window outside the courtroom to your left. I'm going to wish you the best of luck. You take care of yourself, right? Have a good day. I'm caught up.
So this is,
I did not address the infraction. I overlooked that. We'll come back to that point. Good morning, ma'am.
this is Tasha Aronson. She is item number 1 on the 10 o'clock calendar.
Yep.
And, so she intends on entering a straight plea. She does have one prior theft in 2011. She cares more about her record now and how that may affect her employment. So I have persuaded the city to not object to asking the court for a deferred sentence versus a suspended sentence. So just wanted to give Your Honor a heads up on that issue. So that's the sentencing issue, is that we'll be arguing for a deferred sentence with a dismissal if she complies.
With the dismissal, okay.
Yeah,
That's,
you know, so, but anyway, we're otherwise ready to proceed. She signed the form.
Good morning, ma'am. Is your full name Tasha Maria Aronson?
Yes.
I'm looking at a statement of defendant on plea of guilty. It tells me you're 37 years of age. Any problem reading, understanding the plea process and the form? Theft in the 3rd degree is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. But I'd be free to impose that regardless of what's recommended if I saw fit to do so. You give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing, and that would conclude the matter. With that in mind, is one count of theft in the 3rd degree alleged to have occurred within the city of Yelm on February 19th, 2022. How do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made. And your statement of paragraph 11 does satisfy the factual elements. Does the city have anything to add to the recommendation? Mr. Fabico, anything to add?
You know, my conversations with her was, you know, she acknowledged the theft. She described the kind of dire circumstances she was under at the time of this theft and how much she regrets it. She expressed a real, notwithstanding, you know, her culpability, she expressed a real concern about how this is going to affect her employment prospects and seems to have a lot of interest in trying to, you know, kind of keep her life on the straight and narrow. And so I came up with the idea of maybe, because the city, because of her prior, she has a prior theft, but it's quite some time ago. Looks like back in like Puyallup back in 2011. And so I guess out of just trying to be consistent, you know, the city wasn't amenable to a stipulated order continuance, but I proposed, you know, asking for a deferred sentence, and the city said, you know, they're not going to object to it. So I explained to Ms. Aronson that of course it's up to your honor, that you don't have to go along with that, but you know, you have the authority to if you accept the recommendation. So you know, I don't know if you want to address it further.
I would just really appreciate it if and have this on my record.
So. Ms. Aronson, that's one of the realities. If we don't learn from our mistakes, we're condemned to repeat them, and that's what happened here. You got to learn from that, especially with I don't know how much I've read about organized retail theft lately. They just busted somebody up with over $1 million worth of goods. He was taking it in, exchanging it for money, and selling it on one of the many sites online. And I've read about a store recently, a Walmart that closed because they were losing money due to the leakage. I will defer sentence for a period of a year. It's a little cumbersome on how to do that exactly. That's I will impose costs at this time in the amount of $250, payable at $25 a month. And now, the sentence is being deferred for a period of a year. The case will be reviewed in a year if you have a clean record, you haven't reoffended, and the costs are paid, the charge will be dismissed. It's in the nature of the deferral. But as I indicated, it's real important. And try to remember that stores know they're gonna have a certain amount of leakage and they adjust their prices accordingly. So when anybody goes to the store, when they're paying for their own stuff, they're also paying for somebody else's stuff as well. And all I can do is wish you the best of luck. Take care of yourself and if you would, make sure you keep the current address on file and with Mr. Haverkos, just in case we need to have you back. I'm gonna wish you good luck. You take care of yourself. Thank you, ma'am. That concludes the matter. What I want you to do is get a copy of the paperwork at the window outside the courtroom and to your left.
And I need to talk with Ms. Sumi and then Mr. Alfred.
Go ahead. Back on record, Mr. Evercall, defer to you for the order of the,
Thank you,
case
Your Honor.
call.
Thank you. So this judge is Stephanie Sumi. She's item number 10 on the 10 o'clock calendar. I think the parties have reached an agreement. She intends on entering a straight plea to count number 1, suspended driving, 3rd degree, in exchange for which the city will move to dismiss count 2, failure to stop, give information to officer. Recommendation is all suspended jail time and a $250 probation.
Morning, ma'am. For the record, is your full name Stephanie, middle initial M, Sumi?
Yes, sir.
I'm looking at a statement of defendant on plea of guilty to 1 count of driving license suspended or revoked in the 3rd degree. And also there's noted a dismissal of the count of failing to give information to an officer. Have you gone over the plea form with your attorney? And if you had any question about what it meant to enter a plea of guilty, was your question answered? If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing that could be up to 90 days and up to $1,000 by way of penalty. With that in mind, as to 1 count of driving a license suspended or revoked in the 3rd degree, alleged to have occurred within the city of Yelm on May 15th, 2023. How do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements of the plea. Mr. Redfield, anything further to add? Mr. Redfield, anything to add?
Nothing to add, Your Honor.
Assuming you have the right to tell me anything you wish, you don't have to say anything, but I'm going to follow the recommendation. 90 days, all suspended on the condition you simply have law-abiding behavior. And, do you know what it's going to take to get your license reinstated?
What kind of,
Money.
Yeah, we were chatting in the meeting room there, Judge, and I reviewed her case history, criminal history with her as far as with her driving offenses, and it looks like she owes so a couple of another 1 or 2 tickets here, and she looks like she owes around $1,200 or so to, I think, Thurston District Court on a charge, and I explained to her she needs to go to each court, talk to the judge if they're in collections, they haven't brought out collections. Obviously, she's just pleading here, but I think she would be asking the court here if her other Yelm ticket cases have gone to collections here. I think what she's asking is, Your Honor, if you'd be willing to pull them out of collections so that she can try to make good on those tickets. I think she's asking.
Have they gone to collections?
I don't
Do we
know.
know or do we not know?
Yeah,
That's
I
usually, if they have gone to collections, if they've spent any money in an effort to collect them, they usually haven't. They usually just take the referral of the fine and wait for you to go to them. So if they haven't done that, I routinely call them, and my address is sort of, hey, bring in some sort of a down payment, any sort. We'll put the rest on a payment program and then withdraw the FTAs, get those off your driving record so you can get reinstated. That's anything we can do to help with the reinstatement. We'll consider it. We'll do it. On this, payments on the probation fee are $25 a month. Again, if you can't make a payment or you'd rather devote the payment towards relicensing, let us know. And that way we can deal with it. Any question at all? Assuming I'm going to wish you the best of luck in getting reinstated. You take care of yourself, and it's just pretty easy to lose your license. A lot harder to get it back. Once you get it back, make sure you keep it.
yes, sir.
Good luck to you. Take care. If you would, Get a copy of today's paperwork by going to the window outside the courtroom and enter your left. Take care.
I may have to log out of and back into courts. It's not, responding. All right.
Little trouble getting cooperation of vote courts today.
Kind of not.
I think I spotted the problem. For some reason, this will. After I sign it, that's still won't go away. So I try to close it.
Yeah.
Yeah, usually if I click over here, that'll close it, but then I cancel it. And then try and spinning wildly. Big lady shut down. There we go. There we go. Try again. Now I did it. It did that. Wow. Well, I learned something new. Another shortcut. Have it go. Caught up.
I finally got back on.
Mr. Alfred, good morning.
You won't see it. So, matter comes before the court on a pretrial hearing for a theft charge. I think the parties have reached an agreement. He intends on entering a straight plea to the charge. The recommendation is that of suspended jail time, no criminal law violations for 12 months, pay a $250 probation fee.
Morning, sir. Is your full name Danny, middle initial L, Alfred? Mr. Alfred, I'm looking at the statement of defendant on plea of guilty to one count of theft in the third degree. Plea form tells me you're 27 years of age. Any problem at all understanding the plea process? Going over the process with your attorney?
Yep.
If I accept the plea, you lose the rights contained in paragraph 5. There's no trial, no appeal. Simply a sentencing which, since this is a gross misdemeanor, could be up to 364 days in jail and up to a $5,000 fine. You realize that. With that in mind, as to one count of theft in the third degree alleged to have occurred within the city of Yelm on April 23rd, 2023, how do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I do find that the plea is freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements. For the recommendation as to sentence, Mr. Bradfield, anything to add?
Nothing pretty well.
Mr. Alfred, you have a right to tell me anything, anything you wish. You don't have to say anything, but if you have anything you'd like me to know, now's the time.
Would there be a possibility to transfer the fine to community service or something like?
What I prefer to do is handle it this way. We'll say your payments at $25 a month. That's the minimum. Try to make the payments. If you can't, your financial circumstances just don't allow that. Get a hold of Mr. Hammerville, get yourself back on the docket, come into court, and we'll talk about that. It says so many times I said, okay, community service, that's fine. And then people come back later and say, it's just a lot easier to come up with a couple of bucks a month. So let's try the money side first. If that can't work, doesn't work, let us know.
The judgment.
Seems to be. It worked that time. Mr. Albert, I'm going to wish you the best of luck. You take care of yourself. Try not to reoffend. Any questions? Please get a copy of the paperwork at the window outside the courtroom until they left, and you have a great day. The jail time is suspended on the condition that you mostly stay out of trouble. The fine, the probation fee, that's not important, but they do want you to stay out of trouble. Good luck.
Yeah, just go to see the clerk. Yeah.
Thank you, ma'am. And this
is on the 11 o'clock. It's Mr. Martinez Blakely. And it's actually, there's three cases, item numbers 2, 3, and 5. 5 is in a different spot on the calendar because there's kind of a typo and they added 2 M's onto the name, but
that got things out of order.
So matter comes on, 3 matters, each of which is on for a pretrial hearing this morning, protection order violation. Parties have reached an agreement, and I've had an opportunity to discuss these matters with Mr. Martinez Blakely. He's going to be entering straight pleas to 2 counts, which is item number 2 and 3, cases ending in 980 and 490 upon the court's acceptance of those pleas. As part of the plea agreement, the city would be moving to dismiss item number 5, ending in 356. And the fine recommendation is going to be $125 on each for a total of $250.
Morning, sir. You disagree with anything Mr. Aberco just said? I'm looking at your full name is Evan Martinez Blakely.
Yes, sir.
I'm looking at a statement of defendant on plea of guilty to 2 counts of violating a no contact order. There's also involved a dismissal of a 3rd order. Plea form tells me you're 25 years of age. Any problem going over the plea form with your attorney? Able to understand it? If you had any questions, were they answered?
Oh, they were definitely.
Now, if I accept the plea, you give up the rights contained in paragraph 5. There's no trial, there's no appeal. Simply sentencing, which, since these are gross misdemeanors, could be up to 364 days in jail and up to a $5,000 fine. You realize. With that in mind, as to 2 counts of violating the terms and conditions of a protection order alleged to have occurred within the city of Yelm on January 11th, 2023, and again on January 5th of 2023. How do you plead guilty or not guilty?
Guilty.
You make those pleas freely and voluntarily.
Yeah, guilty.
Anybody make any threats or promises to you to make you plead guilty? I'll find the pleas to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements. Heard the recommendation. Dreadfield, anything to add?
Nothing, Your Honor, just ask for a follow recommendation, just all, suspended jail time and a total of $250 between both cases in total, and just law-abiding behavior.
Mr. Martinez Blakely, you have a right to tell me anything you wish, you think I should know. You don't have to say anything, but if you have anything to tell me, now's the time. I see 3 counts of doing the same thing over and over. It makes you question whether or not you actually understand a no contact order, an order of protection.
If I could interject,
Yes.
Your Honor, this stems from a civil domestic issue. There's children in common. And this does not excuse him from abiding by the order. But I think it's important to kind of understand the backdrop here is as to one of the children, I believe at this point, the no contact order admonition may not apply any longer. And there's another child, I believe the admonition will expire, I think, sometime in November. And so this is a situation where, and again, it doesn't excuse him, but the context I think is important because he was contacted by the kids because the kids kind of miss him. And what wound up happening was, well, so anyway, he understands that they have one child in common. And I also explained to him that we had a conversation, I think yesterday, the day before, and part of his challenge is they weren't, I don't believe they were married. And so we talked about how to go about contacting the Division of Child Support to initiate paternity proceedings so that, he could establish a visitation schedule. Because right now, he doesn't, have any legal way at the moment of seeing this kid. So I think he is going to use that information to, because you can apply for services for free through the Division of Child Support. You may wind up in the process, at least with some kind of a pairing plan or something to see the child.
Martinez Blakely, that's a situation that just happens, unfortunately, more often than not. There's bad feelings between the parents. Sometimes that involves the child, and the one that's really hurt is the child, because the child needs parents, and then of course you need to establish your relationships with children. And follow the recommendation, 364 all suspended on each case. $250 by way of probation fee, $125 each case, $25 a month on that. I'm going to wish you the best of luck. Yeah, there's a lot of hoops to jump through to establish visitation, proper child support, et cetera, but you got to jump through those hoops. It's I don't know of any way around it. Good luck to you.
Thank you very much, John.
Martinez Blakely, thank you. Want you to get a copy of today's paperwork at the window outside the courtroom to your left, and good luck.
Thank you very much.
Which means, okay. So what's waiting for me?
Morning, Your Honor.
Good morning. I see 2 things.
We
Mr. Wilson.
can trash the motion.
Okay, got it.
We are gonna proceed with a plea this morning, Your Honor. So we're, So we intend on entering a plea to the violation of order restricting contact, or excuse me, scratch that. We're going to be entering a plea to the protection order violation. And then upon the court's acceptance of the plea, the city will move to dismiss the violation of order restricting contact count. And if all recommendation is all suspended jail time, probation fee of $250, and he has made a statement and asked the court to inquire.
Good morning, sir. Is your full name Mark Daniel Wilson?
Yes, sir.
Mr. Wilson, I'm looking at a plea form that is to one count of violating a protection order. And there's also included a dismissal of a second count of violating an order restricting contact. Plea form tells me you're 40 years of age. Any problem reading through, understanding the plea form?
No, I got one question on the probation. Is there somewhere I check in?
No, it's not that.
Oh, okay.
We
sure.
don't,
Okay.
yeah, we don't have a probation department, a probation monitor, just to make sure, you aren't reoffending. And it's really there to help you out for any,
Yes,
hey,
sir.
I can't make a fine payment this month. Hey, I can't,
Yes, sir.
that's but we're getting the cart before the horse here. That's
Sorry.
and no problem, no problem. You've gone through the process with your attorney,
Yes, sir.
and any questions of me that you'd like to ask?
No, sir.
If I accept the plea, give up the rights contained in paragraph 5, no trial, no appeal, just a sentencing, which could be up to 364 days in jail and up to a $5,000 fine. Realize. With that in mind, it's to one count of violating a protection order within the city of Yelm on October 14, 2022. How do you plead guilty or not?
Guilty, Your Honor.
Do you make that plea of your own free will?
Yes, sir.
Anybody make any threats or promises to you to make?
No, sir.
We'll find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements of the offense. Heard the recommendation. City, have anything to add?
Nothing to add.
Travico, anything to add?
Nothing to add, Your Honor.
Mr. Wilson, anything you'd like to tell me? Now's the time.
I appreciate you guys' understanding and sorry for wasting everybody's time.
You're not wasting anybody's time. We're here anyway, and what we'd like to have, and that's our goal, is just peace and goodwill among all of mankind. These protection order violations and the rules, I've been at this long enough to my tenure as a lawyer pre-existed any such thing as a protection order. They sometimes real troublesome to deal with. I'm going to follow the recommendation. All jail time is suspended on the condition you have law-abiding behavior, and that especially means honoring a protection order and all orders restricting contact, whether we like it or not, and whether they're initiated by others or ourselves. And until a court modifies or withdraws the order, they're there.
Yes, sir.
$25 a month on the probation fee. And again, if there's a problem making the payment, let us know. That's we can certainly deal with that. Any question at all?
No, sir.
Where you go?
Yes, sir.
Place for you to sign. One second.
Now I'll just make the probation payments right here if I don't want to mail them in right at the window.
You bet.
Okay.
Outside the courtroom. And I want that to be your next stop right now, to get a copy of the paperwork today.
Yes, sir.
And review it, look it over carefully. And if you have any questions at all, that's what I'm here for. That's what Mr. Haverco answers his phone for. Mr. Wilson, I'm going to wish you the best of luck. You take care of yourself.
Thank you, Your Honor.
Thank you, sir.
Oh, good plug. There. So, Your Honor, this is, item number 6, last name Rabang on the 11 o'clock calendar. Matter comes on before the court for a pretrial hearing on a theft charge. Had an opportunity to discuss the police reports with her. I believe she's prepared to enter a straight plea guilty to the charge. Recommendation is all suspended jail time. City was customarily recommending a probation fee, but then I would also like to be heard as to the issue of the fee.
Defer with the dismissal.
Oh, no, this is just a suspended jail time, but essentially I'm
Oh,
gonna be
okay.
making a recommendation on the probation fee. Just the customary fee, but she is on assistance and gets cash and food stamps.
Got it.
And so I wanted to make an argument on whether or not the court should impose it.
We'll get to that.
Okay.
Good morning, ma'am. I apologize in advance if I mispronounce your name, but what is your full name? Francisca Lejeune Ganiola Rabat. I hope I didn't mangle your name too badly. I'm looking at a statement of defendant on plea of guilty to one count of theft in the 3rd degree. Plea form tells me you're 28 years of age.
28.
28 years old. Any problem understanding the plea form? Have you gone over the plea form with your attorney? If I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentence. And that could be up to 1 day less than a year in jail and up to a $5,000 fine. That this being a gross misdemeanor, you realize that. Paragraph 5 has a number of rights in it that you're giving up. If I accept the plea, no trial, no appeal, simply the sentencing. You understand that? That in mind is to one count of theft in the 3rd degree alleged to have occurred within the city of Yelm on April 25th, 2023. How do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will. Anybody make any threats or promises to make you plead guilty? I will find your plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Per the recommendation, city have anything further? Any issue, any argument on the costs? Mr. Travico?
Well, she is on public assistance, and I believe receives cash and food stamps and, you know, that's involved, basically taking one extra can of baby formula. That doesn't make it not a theft. She just acknowledged that, by way of taking responsibility in our discussion, is that she was just frustrated at the time. She felt she needed one more and, you know, kind of got upset and didn't maybe think about some other alternative as to maybe how you get more through the system or you get more allotted. And apparently you're given a certain allocation through WIC or whatever it is, and for EBT card only authorized so much. And just she realized it was a mistake and she, you know, sorry for what she did and trying to.
Have you seen a record?
Yeah.
Mr. Bang, anything you'd like to tell me? I've heard the statement of your attorney, but I look at your record and you've been charged with and convicted by court with a theft many times, including a felony conviction for retail, which is organized theft. There's a lot of judges that lock you up for about 90 days on this. And that's going to happen to you at some point, unless you decide to engage on a different career path. But go ahead.
I was using drugs during the time I went to prison for 2.5 years. And,
I'm sorry to hear that.
yeah, I was able to get my life back together. The formula, I was just frustrated with how she was treating me, and I just took off, really. It was my mistake. It was my frustration that I shouldn't have let it get in the way.
I've read in the news and followed the reports on the shortages of and the difficulty in obtaining baby food. And that's, the problem is the past always comes back to haunt you. It's, I'm gonna follow the recommendation, 364 days, all suspended on the condition, you have law-abiding behavior. You're on assistance, you're on public, I'm not gonna impose any fine. But if you need formula, that tells me you have somebody to take care of. And you can't do that if you're locked up somewhere. So stay out, stay crime-free, and, get some time behind you, being away from courtrooms. Any question at all? What I want you to do is, just think about it. We all make mistakes. Sometimes we make them more than once. Forgive yourself, move on with life, and just do what you can. We do the best we can. Good luck to you.
Thank you.
Before you go.
Ms. Ryan, I thank you as well. Good luck to you, man.
Thank you.
or
Good morning. Start again, please. We had to go back on that. Mr. Mead, good morning.
what? So he's in the process of an evaluation and, so that process needs to be, completed. And, so we've just filed a motion to continue. And,
How far would you like to go?
he's been in some contact with Rainier Counseling. I don't
Those
know.
things take time, son.
Yeah, so I'd suggest saying either 4 or 6 weeks.
July 20th, August 3rd,
August 3rd.
August 3rd. City, any objection to a set over?
Okay.
Mr. Mead, we're gonna set the matter over. I realize these evaluations, they take time. I want you to take your time with this. Gonna reset the matter to August 3rd. That'll be at 10 o'clock in the morning. Any conditions of release earlier set, those remain in effect until modified or changed.
Okay.
Any question at all? Stay in touch with your attorney. We'll see you back here in August.
Thank you.
I'm signing the order as we speak. You can get a copy of that at the window outside the courtroom to your left. Good luck to you.
Thank you. Yeah,
Thank you for being here.
I think I just need to speak to Mr. Shaw. One second. This is Mr. Cody Shaw, and he is on the 11 o'clock calendar number 7-8. He's going to enter a straight plea to the theft charge. Upon the court's acceptance of the plea, the city will move to dismiss the other case number, the loitering drug related activity case.
Morning, sir, for the record, is your full name Cody Lee Shaw?
Yeah.
Mr. Shaw, I'm looking at a statement of defendant on plea of guilty to one count of theft in the third degree. The plea form also involves a dismissal of the loitering for drug related activity charge. Plea form tells me you're 29 years of age. Have you gone over the plea form with your attorney?
Yes.
You realize if I accept the plea, you're subject to up to 364 days in jail and or a $5,000 fine, regardless of what's recommended.
Absolutely.
And you give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing.
Yep.
That of mine is to one count of theft in the third degree alleged to have occurred within the city of Yelm on December 21st, 2022. How do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yep.
Anybody make any threats or promises to you to make it? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. I further recommended sentence, I believe, which is all jail time suspended and a probation fee, I believe.
That's correct.
Did you have anything to add to the recommendation? Mr. Averco, anything to add?
Nothing to add, Your Honor.
Mr. Shaw, you can tell me if you have anything you think I should know before I impose sentence. Now's the time. You don't have to say.
Just that one for all of them.
Just that one.
Oh, yeah.
That's, of course, it's sort of my observation that drug-related activity and threats, they kind of go a little bit hand in hand. If the use of substances is getting into situations where you have to come into a courtroom, good idea to maybe rethink the substances.
Yeah, that sure didn't have to do with the other one,
That's
but yeah, I get what you're saying.
I've represented, I think I've lost 6 people to fentanyl over the last year and a half. I think.
Yeah.
Always a good idea to maybe think about that. I cannot tell you how to live your life. That's your choice. It's but I would like to see you save your life. I'm following the recommendation. All jail time is suspended on the condition you pay $250 probation fee, $25 a month, and have law-abiding behavior. That's the most important thing. Stay out of trouble. If again, if behaviors are getting you into trouble, real good idea to maybe modify the behavior. So you stay out of jail, stay out of trouble. Mr. Shaw, get a copy if you would, of the paperwork at the desk outside the courtroom to your left, and good luck to you.
Thank you. And I also had a question, since the drug-related activity was dismissed and simple possession is unconstitutional, does that mean that I could put in something to get my property back then?
Any
Because they
property you
couldn't
have,
take that.
if any property you have that was taken, it could either be evidence of some kind.
Right.
If it's contraband, it would
Yes.
be destroyed. If it's contraband, it would be destroyed. If it was some other property, I don't know what you're talking about. That's a matter to take up with the police department.
Okay, thanks.
Good luck to you and take care. Back on record, Mr. Everco, I'll defer to
Thank
you.
you, Judge. So this is Travis Evans. It's item number 1 on the 11 o'clock calendar. Had a chance to meet with Mr. Evans about his theft charge. Comes on for a pretrial hearing today. He's prepared to enter a straight plea of guilty to the charge. Recommendation is going to be 365 days in jail, all suspended on the condition that he pay a $250 probation fee and not commit any new criminal law violations.
Mr. Evans, for the record, is your full name Travis Michael Evans?
Yes.
Do you disagree with anything at all Mr. Haverco just said?
No.
I'm looking at a statement of defendant on plea of guilty to 1 count of theft in the 3rd degree here on the computer screen. That form tells me you are 33 years of age.
Right.
Any problem at all understanding the plea form?
No.
You've gone over it with Mr. Haverco?
Yes.
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing which could be up to 364 days in jail and or a $5,000 fine, regardless of what's recommended. You realize?
Yeah.
That in mind is the 1 count of theft in the 3rd degree alleged to have occurred within the city of Yelm on September 3rd, 2019. How do you plead guilty or not guilty? You make that plea of your own free will.
Yeah.
Anybody make any threats or promises to you to make you plead guilty?
No.
I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense of theft in the 3rd degree. Recommended sentence is 364 days, but all suspended on the condition you have law-abiding behavior and pay a probation fee in the amount of $250. City, have anything to add? Mr. Havercombe?
Nothing to add, Your Honor.
Mr. Evans, you have a right of elocution. You can tell me anything you think I ought to know or want to tell me about the matter. You don't have to say anything. But now's the time if you have anything you want me to.
No, thank you.
Mr. Evans, I'm going to follow the recommendation. 364 suspended, 250 imposed. The important thing is to suspend the time on the condition of law-abiding behavior, stay out of trouble. That's all I ask. That the jail time is suspended on the condition of that, and that alone. I will sign the judgment and sentence. What I want you to do is get a copy of today's paperwork at the window outside the courtroom to your left. Review it carefully, and if you have any questions, give Mr. Havercole a call.
Okay.
Any questions you might have of me?
I don't think so, thank you.
I wish you good luck. You take care of yourself and have a good day.
Thank you very much. You too.
Mr. Evans, thank you.
I only have 2 no-shows.
We always have no shows.
From the 10 o'clock.
Go back to that. Whoa, I'm shocked. Mr. Hasselman.
I know, I was,
This appears to say that she got. That piece.
right, yeah, I was handed a note by the officer who I assumed that was handed a note by Sonia. Looks like Sonia's handwriting. So there's a phone number, probably John Cassavant called and said he was sick, quote, can't make it, end quote. Now, I haven't been able to have contact with him outside of court yet. I've called on different times and haven't been able to get hold of him. I got hold of his girlfriend, Ms. Moreno, number 8 in the calendar, spoke to her once. But I haven't been able to, wasn't able to get a hold of.
That's
either.
right there.
Yeah. They're
Is she sick too, or?
Well, you know. I guess it depends on what he's sick with.
And that, we don't know, I trust. So, yeah. Well. What would you like us to do?
Well, the defense requested me to note the FTA for speedy trial purposes on both defendants and to reset with notice. I don't know if the city has a different. Decision.
When did the call come in?
Apparently today.
It was about, I think she said around 3 years.
So
Well,
maybe he just found out he was sick at 10:30.
um. Boy. Yeah, you know, what to do.
Oh, no, I've known as to Ms. Moreno. I spoke with her once prior to her last court date. And remember, they showed up late. And so we reset them, and I tried to call her, you know, in anticipation of today's court date, to figure out, you know, what she wants to do, and I just I didn't get it.
And warrants for Mr. Cassavant, 500 each case, and on Miss Marino, 500. On.
And then, what about the one ending in 7819, talking number 3? That was an error on Lazar's part. It's supposed to be the second, which is now a new citation ending in 782.
Dismiss. Dismiss docket number. Docket number 3. Does he have notice of arraignment on? Okay, yep. He's got, okay, great. Warrant on docket numbers 4, 5, and 6.3. And that is, that's it for the Good afternoon. We'll go on record for the 1 o'clock arraignment calendar. You're here for your first court appearance. Before I call you up one at the time, I need to tell you a few things. You do have a right to have a lawyer represent you at all stages of any criminal proceeding, including today's hearing. If you're indigent and request the services of an attorney, one will be appointed for you at public expense. Typically, at this proceeding, a plea of not guilty is entered. That is not any great statement about the case. It's simply a preservation of your rights until you can have what they call a pretrial hearing. That's a chance for you to discuss the matter with your attorney, and your attorney in turn talk to the city's representative. And if the case can be resolved by agreement, that's put on the record. If it can't be resolved by agreement, you have a right to a public and speedy jury trial in the county where the offense is alleged to have been committed. We'll start with, now, if you have any questions about what you're charged with or your rights, go ahead and ask me. Or Mr. Haverco when he comes in. Is Russell Ames here in the courtroom? Hey, Dan? How about Jeremy Brissett? Delphine Cabreros? How about Kinsey DeFord? No luck so far. Adriana Hernandez? Randy Himmelsbach? Are you Ms. Hernandez? Ma'am, come on up and have a seat if you would. Is your full name Adriana Simone Hernandez? Ms. Hernandez, the citation I have alleges that on or about June 12th, 2023, you committed the offense of malicious mischief, 3rd degree. That's what they call a misdemeanor. The maximum penalty on conviction to be 90 days in jail and or a $1,000 fine. You asking for a court appointed attorney? Mr. Haverco will enter a plea on your behalf and discuss that matter with you.
She does want a public defender, Your Honor.
You're appointed?
Yep.
A plea.
Stipulate probable cause, that's the court, dead or not guilty plea.
Mr. Hernandez, a plea of not guilty has been entered on your behalf. We're going to set the matter for the pretrial, and that would be probably on August 3rd, 11 in the morning. I'll say this for everybody. Today's hearing will result in the issuance of an order setting the pretrial hearing date. I want you to get a copy of your order at the window outside the courtroom to your left before you leave. Mr. Hernandez, that concludes today's hearing. Again, get a copy of today's order and then you'll be free to leave. Any questions? See you back here in August. Take care. Randy Himmelsbach does not answer. Zachary Hurst. Zach Hurst. Good afternoon, sir. For the record, is your name Zachary Joseph Hurst? Mr. Hurst, I have two citations. The first one alleges that on or about April 11, 2023, you committed the offense of hit and run attended vehicle. That charges a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. You're also cited for violating the terms and conditions of an order restricting contact That also is a gross misdemeanor. The maximum penalty for that would be 364 days in jail and or a $5,000 fine. Are you asking for a court-appointed attorney?
Yes, yes.
Appoint Mr. Africo to represent you in this matter.
Let's stipulate probable cause, Your Honor, on both cases and ask the court to enter not guilty, please.
Mr. Hurst, any question as to what Mr. Africo just said? Stipulation to probable cause is simply a concession that the officer had a sufficiently legal reason to give you the citation. That's a long way from proving that you committed the offense by evidence beyond a reasonable doubt. Setting pre-trials in your cases for August 3rd at 10 a.m. Conditions of release are law-abiding behavior, and especially with regard to no contact. I think we now have a.
Are you ready? Yeah. Okay, yeah. Go. Thank you.
Good afternoon, Your Honor.
Good afternoon. Are you here on behalf of Mr. Young?
I am, for reason young.
Good afternoon, sir. Go ahead and have a seat if you would.
Thank you.
Is your name for the record Reason, middle initial W, Young?
Yes, it is.
Mr. Young, the citation I have alleges an honor about June 2nd, 2023. You committed the offense of driving under the influence of intoxicants, I believe. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll ask your attorney at this point for an entry of a plea on your behalf.
Yes, Your Honor. For the record, Tony Garza, on behalf of my client, Mr. Young, President Smart, right, would be entering a plea not guilty today. I did discuss the defendant's rights of arraignment outside of the hallway before we came in. He understands those rights. Also understands the charge. Like I said, would be entering a plea not guilty.
I also, I had to pause for a minute. I see you're also on the 2:30 calendar for a contested hearing. Would you like that? Just simply track along with, we'll cancel the contested hearing and then do just that. Mr. Young, I do note I think I have to, I'll hear counsel on that. There was a previous DUI in 2016. I think that triggers the ignition interlock. Any objection or any?
Obviously, we would object to it, but it's, I believe it's triggered by statute with prior.
It is. Mr. Young, that's law-abiding behaviors, usually the only condition I impose. Don't drink and drive. Don't drive unless licensed and insured. And yes, install ignition interlock on your vehicle within the next week and file proof with the court. Your attorney can help you with that. What we'll do is set the matter for a pretrial. I have to go back to
And Your Honor, I believe it was bail posted. Court want to maintain that, or?
that's city have any position on that? I'm inclined to exonerate. Exonerate.
Okay, thank you, Your Honor.
And go ahead and add the infraction. And how far out would you like to go for a pretrial? We have pretrials, private counsel 9 a.m. We have July 22nd. That's today, August 6th, August 20th. Excuse me, yeah, July 6th, July 20th. August 3rd, 17th, or 31st.
The August date was
3rd, 17th, or 31st.
If we could take the August 3rd date.
Certainly. City, wish any additional conditions?
And we can do via Zoom if it's a continuation.
Pardon?
Can, we appear, via Zoom if we continue?
If you
Sure.
wish.
Okay.
If you wish. Yeah, for a pretrial, certainly for any motion hearings or something, I'd prefer in person.
Yeah.
Mr. Young, I'm signing the order. In today's hearing, you can get a copy of that at the window outside the courtroom and to your left. You'll have the pretrial date and time on it. And once again, the only other additional requirement is stay in touch with your attorney. Any questions?
No, nothing further. Thank you, Ron. Good to see
Take
you.
care. Have a good day. Robert Hutzler. Good afternoon, sir. Mr. Hutzler, the city may have a motion in your case. That's docket number 12, page 9.
If your honor, city wants to amend the charge to vote on second degree.
What just happened there is this. As you walked in here, DWS third, that you're cited for, that's a criminal offense. Conviction bears the possibility of 90 days in jail and or a $1,000 fine. The city's amended the charge to a civil infraction. No valid operator's license on your person. Second degree. All I can do if you admit that is impose a fine. If you deny it, I can set it for and will set it for a contested hearing. Any question about what I just said?
No, sir. I'll plead guilty to that.
You don't plead guilty, you admit or deny it, I'll take that as an admission. I'll assess $150 by way of a penalty on the thing. The question I have is this, do you know what you need to do to reinstate your license?
No, I just, you could, papers of driver's license back.
Oh, okay.
So I'm gonna look into.
What I want, but I can't, I'm not gonna order you to, nor can I, but we live in a world where you pretty much have to be able to drive just to function. It's usually a question of money, one way or shape or form, but good idea to get that taken care of, and then get reinstated. Easy to lose your license, hard to get it back, but get it back and then keep. Mr. Hutzler, I'm signing infraction disposition, assessing $150 payable at $25 a month, starting first payment due July 22nd. That's all in the order. You don't need to write anything down. Signing that as we speak. And the copy can be obtained at the window outside the courtroom to your left. That would conclude the hearing, and good luck to you. Thank you for appearing. Any questions?
No, sir.
Take care. Chad Krizan. Mr. Krizan, good afternoon. How are you? Is your full name Chad, middle initial N, Krizan?
Yes.
Citation I have alleges that on or about June 7th of 2023, you committed the offenses of criminal trespass, second degree. That's a misdemeanor. And resisting arrest, that's also a misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. Are you asking for a court-appointed attorney?
Yes.
Appoint Mr. Haverko to represent you, and he's going to enter a plea on your behalf at this time.
I think your honor stipulates probable cause as the court can or not guilty, please.
Mr. Gazan, the plea of not guilty has been entered on your behalf. We're going to set the matter for a pretrial. Conditions of release are law of any behavior that especially includes don't go to premises you've been excluded from. And it's always a good idea to cooperate, at least now don't resist any officer who's performing lawful duty. Any questions at all? Pretrial August 3rd, 11 a.m. Suzanne, any problems, any questions at all?
I'm just waiting for this, I'm just getting down there further.
Yeah, the order will have the contact information from Mr. Haverhill on it. Stay in touch with him and law abiding behavior.
No, specific clarification.
Thank you.
Mr. Kazan, thank you. Alexis Danielle Magnasco. Good afternoon, ma'am. I apologize if I mispronounce your name, is Alexis Magnasco? Citation alleges in honor about March 28th, 2020. You committed the offense of criminal trespass first degree. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll have Mr. Haverhill enter a plea on your behalf today, and he will represent you at public expense. Mr. Haverhill?
I think your honor would stipulate to probable cause as the court to enter a not guilty plea.
A plea of not guilty has been entered on your behalf. That preserves your rights. We're going to set it for a pretrial during the month of August, and I think it'll probably be August. It will be August 3rd, 11 a.m. Conditions of release are law-abiding behavior, stay out of trouble, and stay in touch with Mr. Haverhill. The order that you'll get a copy of at the window outside the courtroom to your left will have Mr. Haverhill's contact information, and I'll need you to stay in touch with him as well. Thank you, ma'am. Anthony Nelson in the courtroom. Christopher Polito. Good afternoon. Your full name, Christopher, middle initial M, Polito.
Originally, I don't have a middle name. I don't know I don't know how they came about, but yes, Chris.
Citation alleges on honor about December 10th of 2022, you committed the offense of criminal trespass first degree. Again, that's gross misdemeanor. The maximum penalty and conviction would be 364 days in jail and or a $5,000 fine. I'll have Mr. Haverhill represent you in this matter. He'll enter a plea at this time.
I think your honor would stipulate to probable cause as the court to enter a not guilty plea.
Set a pretrial in your matter, and that will be, I think, on August 3rd. At 10 a.m. Polito, thank you. You take care. Have a good one. Thomas Wilson.
Yes, sir.
Mr. King, I didn't see you come in, otherwise I would have taken the matter out of order.
Very sorry.
That's,
Your Honor, Mr. Wilson is here for, first appearance on a first offense DUI. You can stipulate to probable cause for purposes of today's hearing. I've already advised him of his constitutional trial rights. We can waive further advisement of rights. And we acknowledge receipt of the citation, so waive any further advisement on that. Request the court enter a plea of not guilty on his behalf.
Mr. Wilson, for the record, your full name is Thomas James Wilson.
Yeah, that's correct.
Charge of DUI, maximum penalty is $364 and or a $5,000 fine. The attorney's pled you not guilty, conditions release or simply law-abiding behavior, don't drive unless licensed and insured. And how about no drinking and driving at all? I'm not asking, don't see the need for any further. Listen, hear from the city and we'll set the matter for a pretrial on
It's on July 20th. Did I hear that was available?
July 20th is, yep, if that works for the city, that works for us. That's it.
Thank you.
And of course, if I didn't say it, the other condition is stay in touch with your attorney and appear for court as directed.
Absolutely.
I'm a little slow on the electronics, Mr. Green. I want to thank you for appearing, Mr. Wilson. You can get a copy of the order for today outside the courtroom to your left.
Okay.
Any questions at all?
No,
You take care. Have a good one.
Thank you, Your Honor.
Good to see you. You take care. And I didn't call for the record, Stephen Scarupa. He's the one that called and go ahead. I think just. If he's ready, he's ready. If he's not, he's. Mr. Scarupa, with this send note the non-appearance and reset it with.
and, all the, Darren, Thomas Brissett, but he's the,
Yep.
the individual that's being,
And warrant or reset it.
reset.
Reset with notice. And we'll see if Mr. DeFord is gonna come in. Apparently, Mr. Scarupa incurred a flat tire on the on his way here and was calling from the side of the road. Sigh. Boy, perfect shows, perfect attendance on the 11 o'clock calendar and not so perfect on the 1 o'clock arena. Is Mr. DeFord going to
He's
grace us with his presence?
just, he's working his way.
Oh, okay, we'll just simply wait until he enters the courtroom. Good afternoon, sir. Call the matter of Yelm versus Kinsey Lee DeFord. Mr. DeFord, come on up if you would and have a seat next to Mr. Haverco. How are you today?
Okay.
Glad to hear that. I have 3 different citations here. The first 2 allege that on or about May 23rd, 2023, and then again on 6/04/2023, he committed the offense of criminal trespass, 2nd degree. That's a misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. You're also cited for negligent driving in the 1st degree. That also is a misdemeanor with the same potential penalties, 90 or 1,000. Are you asking for a court-appointed attorney? I'm going to appoint Mr. Haverko to represent you in this matter, and he'll enter a plea on your behalf at this time.
So Your Honor, stipulate the probable cause on all.
To ask for footage of the negligent driving because it.
Now that's something you discussed with your attorney. It's you can ask for anything you want, but that has to come through your attorney.
I didn't want to.
And now's not the right time. Go ahead. Mr.
Yeah, so stipulate the probable cause on all three matters and would ask for ten or not guilty, please.
Mr. DeVore, we're going to set a pretrial for August 3rd. That's 11 o'clock in the morning. In the meantime, law-abiding behavior, don't drive unless licensed and insured, and also try and stay away from places from which you've been trespassed.
I forgot this time. It was the system for mistake.
Okay,
Yeah.
that's
Not that I remember.
If we get a number, sending the message, put that number on the newspaper. They'll give it to you.
Mr. DeVore, I signed the order of today's hearing. What I'll need you to do is go to the window outside the courtroom to your left and get a copy of the order. It has the court date and time on it, and stay in touch with Mr. Haverko, okay? Good luck to you. And that? Back on record for the 1 o'clock no shows. The first one I have is page 8, docket number 1, Ames. They do find probable cause for the issuance to Mr. Ames of a citation for 2 counts of protection order violation, 2,500 cash or bond. Next one I have is, we did do percent, I think.
Just resetting.
We reset that. And Delphine Cabreros is the next one I have. I did find probable cause when I released her from custody on her promise to appear on June 13th, 2,500 cash bond. Next would be Randy Himmelsback. Find probable cause for theft third on him, 2,500 cash or bond. That was kind of an unusual theft, one that I'd heard of before. You take your car in to Walmart to get new tires put on it, give them the keys. And they'll replace the tires, but they have the keys, so you can't drive it away. You come back after hours in the middle of the night, drive the car off with your other keys to the car. Well, that's a new one on me, I guess. But Hillsack, yeah, 2,500 cash or bond. Then Anthony Nelson. Probable cause was previously found when I released him from custody on his promise to appear on June 12th. 2,500 cash. And the next would be Stephen Skarupa. That's simply, let's reset that with notice given the offenses. And I kept the file. And we'll wait with that, we'll wait for the 2:30. And you are? Good afternoon, ma'am, and you are? Ms. Kirchberger, go ahead and have a seat, next to the microphone there. You were issued a ticket for failure to have, or display proof of liability insurance, back on May 7th. You've asked for a mitigation hearing. That means you'd like me to reduce the amount. It's a
Yeah.
$559 ticket.
Yeah.
And I certainly will reduce it. Have you gotten insurance?
Yeah, I left a copy of it with, but I have a copy with me too.
I'm gonna take your word for it. And oh, yes, you're absolutely right. You got it. That's the important thing. It is required by law that we have insurance and, yes, I see you have the general here.
Yeah, yeah,
And, but if you need it, you sure need it.
yeah.
It is an expense, but, if, unfortunately something happens or you need it, it's a real good thing.
Well,
That's
I
way too
learned
much.
the hard way, because today I've been up all night with a kidney stone and I went to
no.
urgent care. So I'm in a lot of pain, but and on the way home, some guy, the doctor called to say that my CT scan was approved and I answered the phone and I rear-ended somebody and I thank God I have insurance. You know, but the first one, no, but I just can't believe it's just like I bawled my head off and I'm just waiting to go get my prescriptions filled at Walmart, so it'll get better. It's just when it rains, it pours, I guess.
And that's a true story. When it rains, it pours. 150, how about you pay that at 25 a month starting July 22nd?
Okay, I could probably pay it in full by then.
Okay, 150. I'd much rather have you spend your money on insurance than on tickets.
Okay,
Okay, I'm gonna sign an order to that effect. If you want to take care of that today, you can go to the window, outside the courtroom to the left and do so.
oh, okay,
Yeah, but you have insurance now, so yeah, go ahead and keep it in effect.
okay. Is that it?
That's it.
Thank
Ms.
you.
Kirchberger, thank you for your
Thank-
patience. Thank you for
thank you.
coming in. You have a good day.
You too.
When it rains, it pours. True story.